Lakshmikanth polity, Union and its territory. Articles 1 to 4 under Part 1 of the Constitution deal with the Union and its territory. Union of States. Article 1 describes India, that is Bharat, as a union of states rather than a federation of states. This is provision deals with two things: one, name of the country, and two, type of polity. There was no unanimity in the Constituent Assembly with regard to the name of the country. Some members suggested the traditional name Bharat, while others advocated the modern name India. Hence, the Constituent Assembly had to adopt a mix of both India, that is Bharat. Secondly, the country is described as union, although its constitution is federal in structure. According to Dr. B.R. Ambedkar, the phrase Union of States has been preferred to Federation of States for two reasons. One, the Indian Federation is not the result of an agreement among the states like the American Federation, and two, the states have no right to secede from the Federation. The Federation is an union because it is indestructible. The country is an integral whole and divided into different states only for the convenience of administration. According to Article 1, the territory of India can be classified into three categories: territories of the states, union territories, territories that may be acquired by the government of India at any time. The name of states and union territories and their territorial extent are mentioned in the first schedule of the Constitution. At present, there are 29 states and 7 union territories. The provisions of the Constitution pertaining to the states are applicable to all states except Jammu and Kashmir. In the same manner, however, the special provisions under Part 12 are applicable to the states of Maharashtra, Gujarat, Nagaland, Assam, Manipur, Andhra Pradesh, Telangana, Sikkim, Mizoram, Arunachal Pradesh, Goa, and Karnataka. Override the general provisions relating to the states as a class. Further, the 5th and 6th schedules contains separate provisions with respect to the administration of scheduled areas and tribal areas within the states. Notably, the territory of India is a wider expression than the Union of India because the latter includes only states while the former includes not only states but also union territories and territories that may be acquired by the government of India at any future time. The states are the members of the federal system and share a distribution of powers with the center. The union territories and the acquired territories, on the other hand, are directly administered by the central government. Being a sovereign state, India can acquire foreign territories according to the modes recognized by international law, that is, cession, following treaty, purchase, gift, lease, or plebiscite. Occupation, hitherto unoccupied by a recognized ruler. Conquest or subjugation. For example, India acquired several foreign territories such as Dadra Nagar Haveli, Goa, Daman and Diu, Puducherry, Sikkim. Since the commencement of the Constitution, the acquisition of these territories are discussed later in this chapter. Article 2 empowers the Parliament to admit into the Union of India or establish new states on such terms and conditions as it thinks fit. Thus, Article 2 grants two powers to the Parliament: A. The power to admit into the Union of India new states, and the power to establish new states. The first refers to the admission of states which are already in existence, while the second refers to the establishment of states which were not in existence before. Notably, Article 2 relates to the admission or establishment of new states that are not the part of the Union of India. Article 3, on the other hand, relates to the formation of or changes in the existing states of the Union of India. In other words, Article 3 deals with the internal readjustment inter se of the territories of the Constitution states of the Union of India. Parliament's power to reorganize the states. Article 3 authorizes the Parliament to form a new state by separation of territory from any state, or by uniting two or more states or parts of states, or by uniting any territory to a part of any state. Increase the area of any state, diminish the area of any state, alter the boundaries of any state, and alter the name of any state. However, Article 3 lays down two conditions in this regard. One, a bill contemplating the above changes can be introduced in the Parliament only with the prior recommendation of the President, and two, before recommending the bill, the President has to refer the same to the state legislature concerned for expressing its views within a specified period. Further, the power of Parliament to form new states includes the power to form a new state or union territory by uniting a part of any state or union territory to any other part or union territory. The president or parliament is not bound by the views of the state legislation and may either accept or reject them, even if the views are received in time. Further, if it is not necessary to make a fresh reference to the state legislature every time an the bill is amendment to the bill is moved and accepted in parliament. In case of a union territory, no reference need be made to the concerned legislature to ascertain its views, and the Parliament can itself take any action as it deems fit. It is thus clear that the Constitution authorizes the Parliament to form new states or alter the areas, boundaries, or names of the existing states without their consent. In other words, the Parliament can redraw the political map of India according to its will. Hence, the territorial integrity or continued existence of any state is not guaranteed by the Constitution. Therefore, India is rightly described as an indestructible union of destructible states. The union government can destroy the states, whereas the state governments cannot destroy the union. In USA, on the other hand, its territorial integrity or continued existence of a state is guaranteed by the Constitution. The American federal government cannot form new states or alter the borders of existing states without the consent of the states concerned. That is why the USA is described as an indestructible union or union of indestructible states. Moreover, the Constitution, Article 4, itself declares that laws made for admission or establishment of new states under Article 2 and formation of new states, alteration of areas, boundaries, or names of existing states under Article 3 are not to be considered as amendments of the Constitution under Article 368. This means that such laws can be passed by the special majority and by the ordinary legislative process. Does the power of Parliament to diminish the areas of a state under Article 3 include also the power to cede Indian territory to a foreign country? This question came up for examination before the Supreme Court in a reference made by the President in 1960. The decision of the central government to cede part of a territory known as Peribari Union, West Bengal, to Pakistan led to political agitation and controversy and thereby necessitated the presidential reference. The Supreme Court held that the power of Parliament is to diminish the area of the state under Article 3 does not cover such an cession of Indian territory to a foreign country. Hence, Indian territory can be coded to a foreign state only by amending the Constitution under Article 368. Consequently, the 9th Constitutional Amendment Act 1960 was enacted to transfer the said territory to Pakistan. On the other hand, the Supreme Court in 1969 ruled that settlement of a boundary dispute between India and another country does not require a constitutional amendment. It can be done by executive action as it does not involve cession of Indian territory to a foreign country. The 100th Constitutional Amendment Act 2015 was enacted to give effect to the acquiring of certain territories by India and transfer of certain other territories to Bangladesh in pursuance of the agreement and its protocol entered into between the Government of India and Bangladesh. Under this deal, India transferred 3 enclaves to Bangladesh, while Bangladesh transferred 51 enclaves to India. In addition, the deal also involved the transfer of adverse professions and the demarcation of a 6.1 kilometer under marcated border stretch. For these three purposes, the amendment modified the provisions relating to the territories of 4 states, Assam, West Bengal, Meghalaya, and Tripura. In the first schedule of the Constitution, the background of the amendment is as follows. First, India and Bangladesh have a common land boundary of approximately 4,096.7 kilometers. East Pakistan land boundary was determined as per the Radcliffe Award of 1947. Disputes arose out of some provisions in the Radcliffe Award which were sought to be resolved through the Bagay Award of 1950. Another effort was made to settle these disputes by the Nehru-Noon Agreement of 1958. However, the issue relating to division of Peribar Union was challenged before the Supreme Court. To comply with the opinion rendered by the Supreme Court, the Constitution Ninth Amendment Act 1960 was passed by the Parliament due to the contentious litigation and other political developments at the time. The Constitution Ninth Amendment Act 1960 could not be notified in respect of territories in former East Pakistan, presently Bangladesh. On 16th May 1974, the agreement between India and Bangladesh concerning the demo, demarcation of the land boundary and related matters was signed between both the countries to find a solution to the complex nature of the border demarcation involved. This agreement was not ratified as it is involved inter alia transfer of territory, which requires a constitutional amendment. In this connection, it was also required to identify the precise area on the ground which would be transferred. Subsequently, the issues relating to demarcation of undemarcated boundary, the territories in adverse possession, and exchange of enclaves were identified and resolved by signing a protocol on 6th September 2011, which forms an integral part of the land boundary agreement between India and Bangladesh 1974. The protocol was prepared with support and concurrence of the concerned state governments of Assam, Meghalaya, Tripura, West Bengal. That's all. இதுக்கப்புறம் நாளைக்கு பார்க்கலாம்.